You can proceed.
Thank you, Judge Southwick. May it please the court. FedEx terminated Jennifer Harris's employment after she failed time and again to meet the requirements of a managerial position and after more than a year of coaching and counseling. FedEx gave her multiple chances to improve, but when she failed 2 separate performance improvement plans and when the district she led experienced historically poor revenue figures, FedEx justifiably concluded that her employment could not continue. The jury properly rejected Harris's claim of race discrimination, and Harris has not appealed that determination. However, the finding of retaliation and the district court's subsequent judgment rest on at least 4 core legal errors. First, Harris's Section 1981 claim is time-barred by her employment agreement. Federal courts have unanimously upheld 6-month private contractual limitations periods in the Section 1981 context, and Harris offers no justification to create a circuit split. Second, this case never should have reached trial in the first place because no reasonable juror could have found that FedEx's legitimate decision to terminate Harris was pretextual and that the true reason for her termination was retaliation. Third, the $366 million damages award is plainly unlawful. The court wrongly awarded excessive compensatory damages on scant evidence and contrary to this court's maximum recovery rule, and wrongly awarded punitive damages despite no evidence of malice or reckless indifference. Fourth, the district court violated Rule 702 when it permitted Harris's purported expert to rely on her, quote, common sense to state an incorrect legal standard and legal conclusions at the start of trial, irreparably tainting the rest of the proceedings and the resulting verdict. Now, each of these errors was squarely presented to the district court at least once, if not twice, and there's no basis to remand any of these questions of law for additional analysis. We ask the court to reverse the judgment below and render judgment for FedEx. I'll start with the time bar. When Harris joined FedEx, she signed a standard employment agreement in which she agreed to bring any legal action against the company within 6 months of the date forming the basis of the lawsuit. She was terminated in January of 2020, and so she had until July 2020 to file the suit. Instead, she sued in May of 2021. The district court erred in refusing to apply the contractual time bar. The Supreme Court has blessed private contractual limitations periods in an unbroken line of cases stretching back over a century, most recently in the Heimshoff case a few terms ago. And courts uniformly enforce other types of contractual agreements that restrict how disputes will be resolved. Forum selection clauses, arbitration clauses that waive judicial relief, jury waivers, class action waivers, and so on. And so it's no surprise that federal courts nationwide, including the Sixth Circuit and the Seventh Circuit, have unanimously upheld 6-month private contractual limitations periods in the Section 1981 context.
The district court found that this clause related only to the contract, to claims arising within the employment contract, so that the 1981 claim wasn't implicated. Is that an incorrect reading?
Yes, Your Honor, that is an incorrect reading. This is not a claim on the contract. This is a claim of discrimination and retaliation. And I think the way we know that—
Right, but the district court said that the clause, the limitation, only went so far as claims within the employment contract. In other words, this claim wasn't covered.
Oh, Your Honor, I don't think that's correct. The contract terms speak to any claim brought against the company. It's no different from, functionally no different from these types of agreements that other courts have enforced across a broad swath of claims, including the Section 1981 context. And we know that this is not a claim on the contract because her well-pleaded complaint doesn't have any allegations about the contract. She's just pleading discrimination and retaliation. And that's what employers rely on these types of agreements to enforce.
What about the Texas statute that says you got 2 years?
Sure, Your Honor. So that's 16070 of the Texas Civil Practices and Remedies Code. The court should not consider that argument, first of all, because it is forfeited or waived, Harris never raised that argument below, even though this issue was squarely teed up at the MSJ stage and again at the Rule 50 stage. In any event, Texas courts have uniformly recognized that 16070 applies only to claims on a contract, not to civil rights claims, and those Texas state court decisions are dispositive as to this question of Texas state law. And again, we know that Harris did not sue on this contract. She sued for retaliation and discrimination, and her complaint does not mention the contract.
Let's say we agree with you on the 6 months, which takes 1981 out of the picture. I've looked at the jury instructions and the interrogatories to the jury. None of that distinguishes, other than terminology of racial discrimination, distinguishes the Title VII and the 1981 claim. Does your ruling affect anything that was given to the jury, or does it just affect the damages?
Well, so
does it make error in any of the instructions that were given to the jury?
right. So if the 1981 claim is taken out of this case, the primary effect that has is that we're then operating under Title VII, and of course there's a monetary damages cap associated with Title VII that Section 1981 doesn't have. I don't think that would impact in any material way what would have gone to the jury. But of course, turning to what the jury actually looked at and decided, we're asking the court to reverse and render judgment for FedEx because there's no sufficient evidence underlying.
I would agree with that. I'm just trying to see how this plays out. But I think you have answered it, that you don't see it affecting the jury instructions, this error. If we agree with you on the 6 months, which I'm just proposing that in this question, what does that do to what the jury considered? And I think I'm hearing you say it doesn't affect anything that was given to the jury.
Yeah, I think that's right, Your Honor. Functionally, the jury looked at the evidence in this race discrimination or retaliation claim. It rejected race discrimination, and its finding of retaliation is inconsistent with the evidence. And with the court's permission, I'd like to go through that. The FedEx put on overwhelming evidence to show that Harris was terminated based on her performance.
Isn't there evidence that the jury could have relied on to go the other way? I mean, you've got the temporal proximity. Complaint, adverse action, complaint, adverse action, complaint, adverse action, right? Is that enough to go to the jury?
It's not, Your Honor. The Owens case is clear that temporal proximity is not enough.
What if you couple temporal proximity with the supervisor's comments that, no, she's arguing all the time with me? I mean, sort of the annoyance of it and that sort of thing. I mean, was there enough for the jury to infer there?
Well, sure, Your Honor. The answer is no, and there's a couple points there. Let me go through them. First, on the temporal proximity, I think it's important to focus on the timeline, which I think should take retaliation off the table. Harris herself admitted in August of 2018, a full 7 months before she ever engaged in protected activity, that her manager, Michelle Lamb, was dissatisfied with her performance in the Global Gold Rush Initiative. And Harris admitted in October of 2018, again, many months before any protected activity, that her sales numbers were not meeting standards. And so she herself...
Wasn't she getting like good performance reviews and awards during that time frame too?
Not during that time frame, Your Honor. That's the previous time frame. And we don't dispute that Harris was successful in her previous sales role before she took on a managerial role. That is why in March of 2019, when Harris admitted she had not rolled out the initiative as instructed, her manager, Michelle Lamb, indicated to her that her performance was unacceptable and asked her if she'd be happier in her old sales role where she was thriving rather than in her current managerial role. It was then that Harris made her first complaint, only after FedEx had noted her poor performance in multiple respects. We see the same pattern in May of 2019. The fiscal year ended on May 31st, and Harris's team had the worst performance in the Longhorn region. FedEx issued Harris a letter of counseling and her first performance improvement plan. Once again, immediately after that, Harris files another complaint. Harris then fails her first PIP, and Michelle Lamb notes that her performance is not improving. Now, per standard policy, FedEx could have terminated her for failing that first PIP then and there, but instead, Lamb gave Harris another chance. So Lamb issues a letter of warning and the second PIP, and once again, immediately after that, Harris files another complaint.
Mr. Hawkins, I am stopping and I apologize, but going back to that first incident where the suggestion was perhaps you would be better going back to sales, Had there not been a complaint filed at that time by Ms. Harris, what was set in motion? Was there anything that Lamb had said was going to happen, or was this just the beginning perhaps of weekly meetings, if I don't quite recall when that happened? What I'm trying to say is, what did the filing of the complaint potentially interfere with? And was Lamb picking that back up after the complaint was reviewed by FedEx, or was nothing really set in motion by that initial counseling, if that's the right way to refer to it?
Your Honor, that March of 2019 meeting was informal disciplinary process where she's notified by her manager that she's not meeting expectations. They have a serious conversation, and she's asked whether she'd like to be in her previous role. That's not the same as the subsequent letter of counseling, which comes a few months later, or the letter of warning, which comes after that, both of which triggered the performance improvement plans that she ultimately...
Those came after the complaint, right?
Those did come after the complaint, Your Honor, after the first complaint that went to Michelle Lamb's manager and also to HR. I think it's worth touching on the investigations that FedEx did in response to Judge Southwick's question in response to these complaints. And I want to note that it is undisputed that FedEx has robust safeguards and procedures in place when an employee engages in protected activity. Harris filed 3 different complaints, and that led to 3 different investigations. And the record at page 56, 58, and the dozens of pages following show us how those investigations played out. There were communications with Harris, numerous interviews with her peers, review of the records, oversight by multiple different HR professionals.
I thought there was evidence in the record that they didn't talk to relevant witnesses, and they were people that were omitted, that weren't interviewed, and that sort of thing, and they didn't do the investigations timely.
So, Your Honor, that's exactly what Owens is talking about in saying that this court is not to become a human resource manager. It's certainly true that she's alleged that she would have liked those investigations to be
But there was evidence of that, was there not? In other words, we're not being human resources managers, but we are deferential to a jury verdict, and these are data points of evidence on which the jury could have relied, correct?
So, Your Honor, it's certainly true that this court must defer to the jury. I think, though, what's missing here is an acknowledgement that FedEx's procedures and safeguards are in place. There's no dispute about those facts. Now, she's certainly alleged that she would have preferred for Michael Clark to interview different people, to look at different things, have different conversations, but that doesn't make the investigation legally insufficient. What's undisputed...
Does it make a jury issue?
Your Honor, the jury cannot, that does not constitute sufficient evidence to overcome FedEx's legitimate business reason for terminating Harris.
What about the evidence that she wasn't doing as badly as some of the other teams, or there were other teams doing equally badly, I guess, or had similar numbers, and they didn't get disciplined?
So, Your Honor, we've got the evidence set out at page 10 of our brief. She offered up 2 different comparators, Golden McElroy and Brian Hickman. We've set out the data for them at page 10 of our blue brief. Harris's performance, looking at it holistically, was singularly poor. Her comparators are not adequate comparators because they actually showed signs of progressing and improving where she did not. Her numbers in 2018, for 2019 declined while the revenue for every other team increased. Harris's team failed to meet goals all 4 quarters in 2019. And as I mentioned earlier, she disregarded directives regarding the Coach to Grow initiative, and she failed 2 separate PIPs. I'd like, with the court's permission, to touch briefly on the damages issue. For the reasons I've discussed, we're asking the court to reverse the liability determination and render judgment for FedEx. But if the court affirms liability and reaches the damages issue, the compensatory award should be reduced to $15,000 under this court's maximum recovery rule, and the punitive award should be eliminated entirely.
Talk me through the $15K. Where do you get that number? Where's your case to support?
Sure, Your Honor. So the Vady case and the Thomas case that we've set out at pages 42 and 43 of our blue brief, we think are the best comparators because the injuries that the plaintiff in those cases pointed to lines up with her evidence of injury here. She talked about psychological distress, she talked about dry heaving, and she says now that she has to look away when she sees a FedEx truck. That lines up with those cases better than the ones that she's put forward.
How do we discern which cases to choose, or should we remand?
Your Honor, there's no basis to remand here. The court applies remediator and the maximum recovery rule in the first instance as a matter of law routinely, as our cases on pages 42 and 43 illustrate. I think the way the court does it is look at the record evidence that she's put forward and compare it to that of the other cases that we've cited, her cases involve much more egregious facts, much more extreme damages, and much more extreme distress. I see that my light is on. If the court has any further questions, I'm happy to answer them. Otherwise, I'll reserve my time for rebuttal.
Thank you, Mr. Hawkins.
Thank you.
May it please the court, Brian Sanford on behalf of the appellee, Jennifer Harris. I'll just start with the sufficiency of the evidence. We do dispute that we have not shown that she was performing as good or better than her peers. It is not true that she won the award before she became a manager. She won the award her first year of the manager, of being a manager. The next year, as testimony has given, most people who exceed and are superstars and reach the president's level the very next year, because their goals are increased, have bad years. And FedEx itself said at trial, we don't terminate people for one bad year. And they said that we don't coach to a number. We just coach you. They have to pick and choose quarters in order to get her to be the lowest. And if you look at other quarters, or holistically at the quarters, she's not the lowest. There's two others, at least one others. And if you take into account the sabotage of one of the largest clients, BJ Services, which her manager took away, gave to another person, but left the goals back on her and the numbers back on. You take that away, she satisfies another quarter, puts her ahead of somebody else. Yes.
To some extent, what you just said, no doubt is relevant. But FedEx's brief states that when you look at this total time period and you look at the overall team that are relevant for comparators, that your client's overall production was clearly at the low end compared to the others. So individual months, individual itemizations, perhaps there's some people who are comparable, but no other team during the relevant time period, every other team in the relevant time period did better than your clients. What do you say to that?
So
Is that a factual misunderstanding on my part, or
Yes.
is it that FedEx so interfered with her work that is really irrelevant?
No. So we've shown in the brief and at trial that if you look at all of the quarters,
What I'm asking you're talking about snapshots. I'm saying, forget the snapshots. When you look at the overall period, was your client's team the worst off?
No, we proved that there was one other person at least worse off. Two, if you look at the BJ Services. And, of course, if you go back the 2 years when Ms. Lamb became the manager, she's off the charts and beats almost everybody except for one other person.
Again, as a manager or on sale?
As a manager. She won President's Club as a manager her first year, contrary to what counsel said. So she had a trajectory that was going up. They said one bad year doesn't affect you. Everybody was having a bad year, including Michelle Lamb, and not just because of Ms. Harris. And there was an economic problem, an economic downturn. The whole company was having a problem. Not just Ms. Lamb's region, but there was evidence at trial that all the regions under her were all having problems. So they singled her out. Also, the timeline. There was no formal or informal discipline of her until she complained. It was simply a coaching. FedEx says to have an informal discipline, it has to be documented. That's in their policies, or it's not counted as a discipline. And they skipped over that. The manager skipped over the documented discussion and went right to a written warning after the first complaint. So that there isn't a problem in the timeline gap.
Counsel, let me
Yes.
ask you about your expert witness. One of the issues that's highlighted on appeal relates to expert witness Sherrod, I think is the
Yes,
name.
that's right.
Under Rule 702, it says the expert witness's testimony should be scientific, technical, or other specialized knowledge that will help the trier of fact understand the evidence to determine a fact in issue. Secondly, the testimony is based on sufficient facts or data. Third, the testimony is a product of reliable principles and methods. Fourth, the expert has reliably applied the principles and methods to the facts of the case. You're very familiar with those, I'm sure.
Yes.
Would you explain to me how this particular witness's testimony conforms to Rule 702?
Yes. So,
Before you answer, it's undisputed that she did not know the FedEx policy, the human resources policy. Is that correct?
I don't know that that's correct. I do not know that that's correct. I'm not.
Conceded she'd not even read them.
Yeah, she may have. That may be the fact. That's not what she was testifying to. What she was testifying to is, I think she even said this, everybody has the same policies. All the companies have basically the same policies that say the same thing over and over. It says, we want to follow the law, we don't want to discriminate, we don't tolerate discrimination, we don't tolerate retaliation, and we intend to prevent it, which is what their policies say. So that's not the issue, because just because you say it doesn't make it so. The issue is, how do you perform that, and what are the industry standards for complying with those policies, which are simply complying with the law? And that's what she testified to.
Did she offer an ultimate opinion as to what FedEx did as insofar as it being sufficient or insufficient?
She did, simply based on an assumption. So what she said was, look, I've been given a set of facts, and I'm assuming that those are true. If those facts are true, then FedEx, she didn't even say violated the law, didn't meet industry standards.
Well, what
So-
she said, I thought, was there was retaliation and
There was-
discrimination.
No, she said the root cause was failure to monitor to prevent retaliation, failure to follow policies to prevent it. And it could have been prevented had they followed the industry standards. That's what she was testifying to. She didn't testify to a duty. In fact, HR said we have a duty to prevent retaliation. She did testify to a statistic about 75% of people fear retaliation, but their own HR person acknowledged that they rely on statistics, and that sounded like something that they would have relied upon. That's in the record too, at 44, 26, and 7. So she simply is testifying. She was 20 years practicing. She's a vice president of human resources. She has a bachelor's and MBA degree. She is double certified, unlike their HR, are not certified. And she was testifying to industry standards. And that's exactly what experts do. In fact, their HR people are testifying to what they believe standards are. So she's simply just giving the plaintiff's counter view of what standards should be so that a jury can make a decision and make a call.
Let's talk about the Section 1981 claim. How's it not time barred?
So, yes, it's true that no other case has said that, but no other case mentions the Supreme Court case in Burnett versus Groton. None of them saw it. I would venture to say it wasn't even briefed.
It's not that the courts haven't said it, it's that they've upheld them.
They've upheld them, but they haven't. Yeah, they've upheld them without mentioning the Supreme Court precedent contrary. So the Supreme Court has held that a 6-month limitation for a Section 1981 claim is unreasonable and violates public policy.
That was the Maryland case?
That was the Burnett case, yes.
That's a Maryland statute.
It's a Maryland statute.
Here she agreed to it.
Yes, yes. And the Supreme Court has also said in the Wolf
Supreme
case,
Court's never overruled a contractual agreement like this.
the Supreme Court has said in the Wolf case that a contractually shortened limitation period must be reasonable and fairly imposed to be enforceable.
But these have been upheld as reasonable and fairly imposed.
Well, we have, without considering these two Supreme Court decisions. So we have a very classic syllogism with those two Supreme Court decisions. If
In the Burnett decision, though, just distinguishable in the way that Judge Wilson is saying, is that it was not a contractual agreement agreed to. Of course, you say it was unknowing and whatever else, but that's just in the nature of contracts, how much you have to read them. That there's no case, and Burnett isn't one of them, that has set aside a 6-month limitation if the party agrees to it by signing the contract.
There is
And
no.
so Burnett is eminently distinguishable on that basis.
So here is the inescapable logic. There is a Supreme Court case, the Wolf case, 1947, it's in the brief. The Supreme Court says a contractual agreement to shorten a limitation period is not enforceable if it's not reasonable or fairly imposed. So, syllogism. If to be enforceable, all contractually shortened periods must be reasonable, and Burnett, a 6-month limitation for Section 1981 is not reasonable, then a contractually shortened period of 6 months for a Section 1981 claim is unenforceable. Those two cases lead to that inescapable conclusion. That's what, if this makes it to the Supreme Court, I believe is going to be.
We will evaluate both sides' arguments on
Right,
that.
okay.
Let's premise for this question that we disagree with you, and 1981's off the table. Respond to where we are on the jury verdict.
Well, then we're left with Title VII, which is capped at $300,000. And so it's a $300,000 claim with a possible reinstatement and attorney's fees. So it's remanded back for reinstatement and attorney's fees. That's the bottom line.
Well, do we cap it at $300K, or do we go, what about the max recovery rule? Your counsel opposite says it's $15,000 for.
Yeah, so we disagree with that there is a case that's close enough for the maximum recovery rule. There is no other case.
You argue in the brief this is an exceptional case and this is
That's
beyond the pale. I mean, I see it as sort of a run-of-the-mill case, and so assuming we disagree with your point on that, then how are we to sort through which cases to apply? Is it $100K? Is it $15K? is it nominal damages? And that informs the punitive multiple, right?
Yes. So we would say the jury got it right with the $1,180,000. We do not say, we do not concede that her facts are anywhere close to any other case. She has esophageal damage. She has, there was sabotage. There was the statements against her about what had happened. There is looking at the FedEx trucks every day. There is living. The jury's job is to make her whole for the rest of her life.
Counsel, let me ask you about the punitive damages, though.
Yes.
You'll agree with me that they're rather extraordinary. How do you defend them under the BMW of North America case and our authority in Abner versus Kansas City?
Yes. So under the BMW and the State Farm case, yes, there's enormous pressure to reduce those down to single-digit multipliers of the compensatory. We would not concede that it should be, but if the court was going to reduce that to that, what we would say is that the compensatory damages should stay in place, $1,180,000. The punitive damages should be limited to 9 times. Not conceding this, I'm just giving an alternative. 9 times, which would be a little over $10 million, so that a reasonable alternative would be allow the compensatories to stand and a $10 million punitive damage limit. I will make the argument.
I'm sorry.
If I make a real quick argument about the Supreme Court. The Supreme Court says there's no bright line. The plurality in the BMW case was having a hard time overcoming the substantive due process that was being overlaid in our Constitution dealing with 2 state laws. And of course we had dissents, including Scalia and Thomas, saying this is substantive due process, we are not agreeing to it. Dobbs recently has said we're not doing that anymore. So there's an issue there.
Well, what I was going to ask you, and sorry to interrupt earlier, but let's talk about the underpinnings for punitive damages.
Yes.
FedEx argues that there's not sufficient evidence for it. What is the evidence of malice here on the part of FedEx?
Oh, well, so they've known about just a systemic problem. There was evidence of a systemic problem, not just her, but others. They willfully are not training their HR. They're not qualified. They're not certified. They are overworked. They're looking at 2,000 employees at a time. Their investigations were a sham. The investigation reports even substantiated, if you look at the actual reports, her claims. So she was saying, I wasn't given, they didn't communicate when they took my goals away from BJ. That was substantiated, although he said it wasn't. The actual report substantiates that. That she wasn't allowed to participate in training, that's substantiated. That this global reach was taken from her, that was substantiated. That there was problem emails, that was substantiated. So the fact of multiple sham investigations, ignoring the law, not putting systems in place.
What is your evidence that the investigations were sham investigations?
So I've just laid that out. So for instance, she complained that she was not consulted on the transfer of the BJ services, which is company policy. The report says and shows that she was not consulted. Yet it says her claims are not substantiated. That was substantiated even in the report. It says that she was not allowed to go to this management training program when everybody else was. That was substantiated, even though the investigator says it was not. His own report shows it, that there were problem emails. That was substantiated. That she had been experiencing hostile work environment, being treated differently. That wasn't included in the report, but it was the witness said, yes, he interviewed me, and I told him that I observed Miss Harris being treated differently and in a hostile manner, not like anybody else. She was the only black of the district managers reporting that same person. So that's at least a litany that I could say right now on those for the sham investigation. So I will go back to compensatory damages here, and the sample size is too small to apply that, and I think, Your Honor, you were alluding to that a little bit earlier. We don't have that many cases to compare. So the first cases are going to be unique. We don't know where these cases settle. We don't have arbitrations out there. I had another case with a client, an arbitration, retaliation employee, where the arbitrator, former trial judge, awarded $1 million in mental anguish. So this is not something that should be mathematical and arbitrary. And I'll just put it in context. There was an employee by the name of Nolan Ryan. There was the first professional athlete to make a compensation of $1 million a year, which was considered nuclear at the time. And now that amount for a professional athlete as an employee is minimal, nominal. So I would just say, the genius of our Constitution, some say, is its faith in our citizens and the jury. And this is their job to decide these very kinds of things. How to make somebody whole in compensatory damages. And we would say that the $1 million is not something that's out of the ordinary or too high. And then, of course, you build from there on the punitive damages. I'll yield back my time.
Right, Counsel.
Thank you.
Just a few points in rebuttal, Your Honors. I think it'd be helpful to take a step back and look at what's not disputed. I heard some allegations about whether Jennifer Harris was performing well or not. What is not disputed here is that she failed 2 different performance improvement plans, and that by FedEx policy, that is ground for termination. Their disputes about the degree to which she was struggling are irrelevant to that question. Second, there's no dispute as to the existence of the safeguards grounded in cross-departmental checks and balances that I went through in my opening presentation. And third, there's no dispute about the timeline in this case. Now, at pages 36 and 37 of our brief, we talk about the Eubanks case and other cases as examples of instances in which retaliation has been overcome based on a manager's prior negative impression of an employee's performance. Now, she says that Michelle Lamb violated FedEx policy by not documenting that prior discussion. That's not correct. I'd refer the court to page 5758 of the record. It shows that Lamb had discretion to make a documented discussion and did not exercise it. Of course, that does not constitute a violation of policy. And then finally, I think it's worth stepping back and looking what she's asking for here in light of this timeline. If this court were to uphold retaliation on these facts, it would allow employees to immunize themselves against termination by simply engaging in protected activity every time they are disciplined or reprimanded by a manager for poor performance. That's not the law in the circuit. That's never been the law in the circuit, and that cannot be the law in the circuit. Just a few other points on the. Oh, I'm sorry, Judge Southwick.
Excuse me, you don't have much time. It seems to me that one of the problems in the case is just the frequency of what Supervisor Lamb did. This initial discussion that you called informal, complain about it, reviewed, and then some sort of discipline imposed. Another complaint, investigated, discipline imposed. You seem to me you have a better case if it sort of ended after the first time, but Lamb kept doing that almost. I mean, she said that the plaintiff was not respectful of my opinion in listening to this criticism. I mean, what do we do with the frequency of this? Not so much temporal proximity, but just the frequency of Lamb responding with some sort of discipline.
Sure, Your Honor. Let me point Your Honor to two things. First, there's no dispute that Harris was struggling in her job long before she engaged in protected activity. Second, I would refer the court to what Michelle Lamb's actually said. I think the two important parts of the record are page 5947. That is Michelle Lamb's August 2019 email. Now, Harris says that shows that Lamb is complaining about her performance in collection with opposing the discipline, but in reality, in that email, Lamb is laying out 3 different examples of insubordinate behavior, all relating to the same criteria that apply to everybody else. I'd also refer the court to page 5742. This is the December 2019 request for termination, which lays out all of Harris's deficiencies. That constitutes the type of overwhelming evidence that does not allow a jury to find retaliation. And of course, we haven't spent much time talking about Judge Engelhardt's opinion for the court in the Owens case. Owens illustrates that this case never should have reached trial in the first place. And indeed, this case is even easier than Owens because in Owens, the plaintiff succeeded in sales but failed in leadership and management. Here, Harris failed in sales and in her leadership and management. And as a result, this case never should have gone to a jury in the first place. Briefly, just a couple things on damages. I want to emphasize that I think one of your honors observed earlier that there's limited evidence supporting the award of future emotional distress. That's exactly right. In fact, there's almost no evidence. Harris testified that she's now got a job at McKesson that she's doing well at. She runs a t-shirt printing business that she's doing well with. There's simply nothing in this record to support the $1 million plus award of future emotional damages. Likewise, the evidence of past emotional harm is scant, and as I discussed with Judge Wilson on my opening presentation, the cases make clear that this court can and should decide that issue as a matter of law. There's no basis to remand. I'll just use my last few seconds to just conclude with what we're asking the court to do. We're asking the court to reverse and render judgment for FedEx on the basis of liability. That takes care of all the other issues in the case. There's no need to weigh in on anything else. FedEx is not liable as a matter of law. But if the court disagrees, we would ask the court to hold that the 1981 claim is time barred. May I finish this? Hold that the 1981 claim is time barred, remit the compensatory award to $15,000, and hold that no punitive damages are available as a matter of law.
All right.
Thank you, Your Honor.
Mr. Sanford, thank you both for your presentations today. We'll take this case under advisement.